Good afternoon, ladies and gentlemen. Greetings from The Hague. The African Arbitration Association is finally a reality. I am delighted by this felicitous development. After our decision in Mauritius to create an umbrella organization, there was for some time some doubt as to whether there would be one or two associations. I was profoundly concerned by that development, but I am very happy today that a sense of Pan-Africanism has finally prevailed. I am therefore pleased to be able to address you today. I have not been able to be with you physically in Abidjan and now in Kigali, but you can always count on my support to the association and its activities. Before addressing the expectations engendered by the creation of the African Association and the challenges facing arbitration in Africa, with which of course the association will have to engage, I will say a few words about arbitration, particularly arbitration across boundaries, be it interstate or investor-state in Africa. We don't have any written records indicating the conclusion of agreements between African states in the pre-colonial period to settle their disputes through arbitration. However, given the widespread use of arbitration for the settlement of disputes in general throughout the continent and its important position in customary law in many African countries, it is very likely that great empires like those of Mali, Songhai, or Benin may have actually resorted to it in the settlement or peaceful settlement amongst themselves of disputes or disputes with other entities. What we have are examples of agreements concluded between African entities and foreign powers. One such example is the treaty concluded on 22 January 1682, that's in the 17th century already, between the Sultan of the Sharifian Empire of Morocco at the time and the French King Louis XIV, which provided, among other things, that arbitration would be the mode of resolution of any potential dispute related to foreigners visiting or living in Morocco. In other words, an agreement similar to today's investor-state treaties, the BITs. Another example, of course, is the arbitration of 1861 between the Sultanates of Zanzibar and Muscat, which was carried out by the Governor-General of India at the time. As you may recall, or some of you may have read about it, the two sultanates were brothers that were in dispute over the territories each held following the death of their father, Said Barkash, the ruler of both Zanzibar and Muscat, which is the Oman of today. In his award, the Governor-General declared the Sultan of Zanzibar to be the successor to all their father's African territory and ordered him, since he was the wealthier of the two at the time, to pay 40,000 crowns to the Sultan of Muscat annually as compensation for the abandonment of all claims to Zanzibar. Both sultanates accepted the Governor General's decision, and the award was implemented without any issue. We may also mention, as another example of the history of arbitration in Africa, the Spanish Zone of Morocco claims. It was not formally an arbitration, but it was related to damages caused to British subjects and protected persons in Morocco between 1913 and 1921. And Morocco and Spain, the United Kingdom and Spain decided to call upon the services and the knowledge of a great arbitrator of the time. So they selected Max Hooper, who was a judge at the Permanent Court of International Justice, as rapporteur. They didn't call him arbitrator, they called him rapporteur, to prepare a report. And they also selected Mr. Eke Hammarskjöld, who was at the time the registrar of the court, as the secretary of the commission, in a way, which was entrusted with producing an award or a decision which would settle the claims between the parties. All aspects of the case were unanimously approved by both litigants, and they were extremely happy with the award and the report, which was produced by Max Hooper. And Spain was so happy that it even offered the Order of Isabella to Max Hooper, an honor, of course, which he could not accept because of his judicial office. As you all know, 4 years after 1960, the symbolic year of Africa's independence, African states adopted in Cairo a protocol on conciliation, mediation, and arbitration. Such peaceful means of dispute settlement had already been enshrined in 1963 in the Charter of the Organization of African Unity, with the establishment of a commission of mediation, conciliation, and arbitration. What is striking about both the protocol and the Charter of the OAU is that they do not mention, they do mention arbitration, but they do not mention the judicial settlement of disputes. I think that one can perhaps give two reasons for this omission of judicial settlement of disputes. Firstly, as newly independent states, African states were jealous of their sovereignty in the same way that the European powers that gathered in The Hague in 1899 and 1907 refused to establish a judicial institution and instead established a permanent court of arbitration, which exists up to now. So in the same way, African states were living their Westphalian moment when they said, we accept arbitration, but we are not yet ready for an institution which would engage in judicial settlement of disputes. And of course, the second reason is that traditional dispute settlement in African states before colonization was for the most part arbitral, not judicial. The traditional institution of customary arbitration prevailed throughout pre-colonial Africa, but later disappeared under layers of colonial legislation which most often were not actually adapted to the conditions in Africa. So despite the manifest faith put in arbitration as a system of dispute settlement, neither the protocol nor the commission were actually used by the African states, and that is very unfortunate. And that is why the commission disappeared and died of disuse, because in the 1960s, 70s, and even early 80s, African states showed a clear preference for direct negotiation and mediation as methods of dispute settlement. Neither arbitration nor judicial settlement was resorted to by most of the African countries. This situation has completely changed in recent years. I think that in the last few years you can see that African states have placed a growing confidence in international law, due, of course, to its transformation, I would say, and to its progressive development in the 1960s and 1970s, thanks also to initiatives undertaken by African states together with other developing countries, particularly Asian countries, and through sometimes the Asian African Legal Consultative Committee, which has now become the Asian African Legal Consultative Organization. So with regard to interstate arbitration involving African states, I will refer briefly to two tribunals set up to arbitrate disputes between Eritrea and Ethiopia on the one hand, and Eritrea and Yemen on the other. The Eritrea-Ethiopia Boundary and Claims Commissions, because two commissions were set up actually, one for boundary delimitation and the other one to deal with the claims by both parties, were set up to delimit the disputed boundary between the parties, but at the same time also to award reparations for breaches of international law committed during the parties' two-year conflict in 1998-2000, respectively. The Eritrea-Yemen Tribunal was a different matter. It was charged with determining the sovereignty over disputed tribunals and to delimit the parties' maritime boundary in the Red Sea following a conflict between the parties in 1995. The good news is that both awards have now been complied with. As you know, there were difficulties for the implementation of the delimitation of the boundary between Ethiopia and Eritrea, but this matter has now been resolved thanks to the initiative of the new Prime Minister of Ethiopia. Turning now back to the association, because that is really something which is of utmost importance to all of us here today. What are the challenges facing arbitration in Africa which the association can help overcome? I would give you perhaps 3 or 4 examples. The first one is the geographic delocalization of the arbitral process. The fact that arbitrationists and arbitral tribunals involving African parties take place far from the African continent and far from African countries, either in Europe or in the United States, presents a major obstacle to greater acceptance of arbitration in Africa, particularly by the common people. Arbitrationists need to be held close to those that are affected by the tribunal's decisions, and they need to be covered by the local press so that the stakeholders can follow what is taking place in the arbitral tribunal and how that arbitral tribunal comes to a final decision or an award. This transparency is of utmost importance, and therefore it has to be encouraged. But the task of the African Association, a primary task, I would say a principal task, is to promote relocalization and repatriation of arbitral tribunals dealing with disputes relating to Africa. A second challenge in which the role of the association will play will be very important. African states should realize that the arbitral tribunals in which they participate would have more legitimacy in the eyes of their own population if the arbitrators were not all foreigners, but most of them were African arbitrators. In the arbitrations that I have just mentioned, between Ethiopia, Eritrea, for example, and Eritrea, Yemen, only 2 of the 15 members of the arbitral tribunals were African. Investor state arbitral tribunals are much worse. There are only very few Africans who sit on investor state arbitral tribunals. Most African states never appoint an African arbitrator to sit on such tribunals. It is the task of the association to change this most undesirable situation and to promote the participation of qualified Africans in arbitral tribunals dealing with African disputes. A lot of sensitization is needed here, but you can do it, I'm quite sure. Thirdly, it is the task of the association to foster the training and accreditation of African arbitrators in Africa. We don't need to seek accreditation from abroad. Africans can create and should create your own Pan-African system of accreditation, which unifies different accreditation systems used in different parts of the continent, which are most often a legacy of colonialism. The African Institute of International Law in Arusha has prepared and is ready to roll out a full-fledged Pan-African program of training and accreditation for African arbitrators. The association has to partner with the institute and work with it so that all African hands are on deck for this major undertaking. You need to unify and not to disperse your efforts in order to achieve tangible results on this very important task. Finally, you have heard me refer several times to Pan-Africanism. This is a matter of utmost importance for me. I hope it is equally for you. We are still divided in the continent by various colonial legacies. This is also true in the area of law that's applied in the continent in general, and of course of arbitration, which applies that law. We need to overcome those divisions. I count on the association to unify African arbitral practice, to reject divisions based on colonial legacy, and to promote a Pan-African arbitration culture which brings together all African countries in this field. This is the only way and the only time that African arbitration will truly come of age. Thank you.